Welcome, everybody. Thank you very much. Thanks for taking some time this evening to talk about estate planning, wills, trusts, beneficiaries, power of attorneys, you name it. This is part of our client education series. And, over the years, I do get a lot of clients that have asked me over the last 24 years of working with folks with retirement planning that are asking, hey, Tom, do I need a trust? What's the difference? How do I do this? And I know enough to be dangerous, but I thought it'd be a good idea to have someone that we know, a professional, established estate planning attorney here in St. Louis, Lauren Gilliam, come on and do a live webinar to go over the basics of just those topics and why they're important. And let me introduce Lauren here. She is not my sister, although we share the same last name. She is my cousin's wife, and she's been a long-time estate planning attorney here in St. Louis, based out of St. Louis. Many of my clients have used her over the past several years, and I get rave reviews, but she's been kind enough to give up part of her evening here. This is live, and she's live, and we want to go over the estate planning basics. Without further ado, let me turn it over to Lauren.
My name is Lauren Gilliam. I am an estate planning, probate administration, and trust administration attorney. I am a proud Mizzou graduate. I did my undergrad at Mizzou, and then I graduated from SLU Law. So, strong ties to Missouri. I have been practicing in St. Louis and practicing estate planning for going on about 13 years now. So have lots of fun stories that I can share with you. But tonight I just want to go over some of the essentials just to give you kind of a 101 or a primer of the real important things that you need to know. And then I'm happy to answer any questions at the end, like Tom had said. And then we can also always schedule a consultation where we can talk about your individual needs. Consultations are always free. So the core elements of an estate plan, you'll want a financial power of attorney and a medical power of attorney. Now, those two documents are only valid while you're alive. You also want a last will and testament, and then either a living trust or what we call probate avoidance devices. And so that last piece is where everybody will fall and say, which one do I need? And it's a very fact specific determination. Living trust is always the best method. But there are some people that you can really, could fall into, let's just get you that basic estate plan and make sure that we're really careful with what we do and keep that in mind. So let's look at the different elements kind of broken down. Okay, so some of the benefits of having a revocable living trust is that it avoids the time and expense of probate. I recently just had a client come to me. Her aunt had passed away, and she was in the process of transferring or updating her beneficiary designations. She had had a financial planner that wasn't doing due diligence. She didn't have any beneficiaries listed on any of her accounts. So when the accounts got transferred to this new planner, alarm bells went off and they said, we've got to get this taken care of. So they were in the process of updating everything when she died. And $300,000 ended up being subject to probate. So that's going to take at least 6 to 9 months to get that through probate. And 3 to 5% of that $300,000 is going to come out. So that is roughly $9,500 that will go to both the attorney and the personal representative. So that is a big chunk of money and a big chunk of time that you can avoid if you set up a trust. The other big benefit is that the details of your estate remain private. if you are kind of an estate planning nerd like me, you can go online and you can actually look up Elvis Presley's will. Uh, any will that's filed for estate administration is a public document. So if your will has to be administered, anyone can go online and look at it. And with the accessibility of CaseNet now, and that it's now completely open to the public, there are so many details, even though your social security number and your birthday will be redacted. There's a lot of distribution and family information that is not redacted that's going to be out there, that you might not necessarily want people to know. The other nice thing about a revocable living trust is that you can update it and modify it at any time. You can revoke it, you can amend it. You're not locked into it. So just because you set it up doesn't mean you can't change it. But the nice thing is that once it is set up, you have one name for it. So you can modify the insides of the trust, but you don't have to change your beneficiary designations over and over and over again. And then the other thing is that it immediately transfers your property in the event of incapacity. So if you become incapacitated, your successor trustee can take over and start caring for you with your own assets without having to worry about getting the assets won't be tied up. They won't have to go through any kind of a court administration. They will be immediately accessible and they will be there for your use. So those are all reasons why you would want to set up a revocable trust. The other great things about a revocable trust, or things that you want to consider, are if you have minor children. You can't leave money outright to a minor child. So in the state of Missouri, if you leave money to a child that's under the age of 18, that money will go through probate. They will have to name a conservator who will have to report to the probate court every year and say how they've been spending that money on behalf of that minor child. When that child turns 18, they immediately get access to 100% of those funds. A trust can also be nice if you have someone that you have in mind as a beneficiary who's not responsible with their finances. So you can structure it so that they don't have access to 100% of the principal, that there's a trustee that's there that is managing the money for them and distributing things to them over an annual basis. You can also set up a special needs trust within a revocable trust. So if you have a beneficiary that's receiving some kind of government-based benefit, that you won't disqualify them from receiving those benefits just because you're leaving them an inheritance. So you can leave an inheritance that will supplement their government benefits. You can also decide how your estate is distributed. So you can say, if you have children, you can say, I want my 3 kids to be able to access 25% of the principal when they turn 21. And then I want them to be able to access up to 50% by the time they're 25. And then when they turn 30, they can get all of it. But they don't have to take all of it. They can leave it in the trust and keep it protected. The other reason that a trust is nice is when you do have a complicated distribution scheme. So if you have multiple children, you don't have to update the beneficiaries multiple times. So you would establish the trust and then you would fund the trust. So once that's set up, say you name your brother as a beneficiary and your brother dies before you and you don't have a trust, you would have to go back to Tom and say, Tom, my brother died. I need to update my beneficiary designations. If you had a trust set up, the trust could handle that contingent beneficiary issue. The trust would be the beneficiary of that account and could plan for all of those different situations. So you could say, I want it to be my brother, but if my brother doesn't survive me, then I want it to go to this person, or I want it to be distributed to 4 or 5 different charities, or you can be as specific as you want and be as creative as you want, where beneficiary designations kind of lock you into a form. You're not able to make those complex situations happen as well. Something to consider too is if you have adult children and you might have potentially grandchildren, you don't have them now, but it's something that you might want to plan for in the future. And sometimes people say, well, I don't have a ton of money, but you might have a lot of life insurance, or, you have a lot of equity in a home, things like that. Those are reasons why a living trust would be right for you, is to set that up, and have those assets protected. So then the next piece of it is a last will and testament. So everyone needs a will, even if you have a trust, because the will is where you're going to appoint guardians for a minor child. Even if you have a trust, you would need a will, in case there's anything that you forget to put into the trust before you die. So it would essentially just tell the probate court, they've got a trust set up and we want that to govern. So go ahead and get these assets out of probate and put it into the trust and let the trust go from there. But the will is where you can also put directions on what you want, as far as if you've made funeral arrangements, if you want cremation or burial, things like that. Um, and you can designate your beneficiaries. So a lot of people don't know that in Missouri, if you don't have a will, you're subject to what's called intestate succession. So say you're married and have children and you don't have a will and something goes through probate. Your spouse will get the first $20,000 and then they get 50% of that asset. Your children get the rest. And then if they're minor children, that money gets locked up in a conservatorship that has to go through probate, and your spouse will have to go report to the probate court every year until that minor child turns 18. But all of that could have been avoided if you had a trust set up or if you had a will set up. It was a really interesting situation. I had a client come to me and she said, Lauren, that account was actually in his trust. At that point, she could step in and invest it. But if that was something that wasn't actively in his trust, there was nothing she could do. With a medical power of attorney, that is where you'll have somebody that can be making your medical decisions if you're unable. That is where you can have a medical directive. It's also called a living will or an advance directive, which is if you are in a coma or if you have a terminal condition, you're unable to communicate your wishes, there's no chance of recovery, and you do not want life prolonging measures, then you can state that you want that withdrawn. And that actual piece of the document will stand on its own so that no one actually has to make that decision at the end. So it's there and it's telling the medical staff what to do. And it will also give your power of attorney the confidence to know what you want. Within the medical power of attorney, the one piece that remains after you die is the right of sepulcher. So that is the right to dispose of your remains. So your power of attorney can designate whether you'll be cremated or have a funeral. They can arrange for burial. They can donate your organs. And you can also prohibit organ donation within your power of attorney. So I have a lot of clients that are like, absolutely not. I don't want that. That's where you do it. I had a call one time. It was really interesting. Missouri, it was within the last 10 years that Missouri added the right of sepulcher as a requirement, and something that went on past past death within the medical power of attorney. I had a call from the funeral home and they said, I've got this power of attorney, but it doesn't have the right of sepulcher in there. And it was a girlfriend and a daughter that were fighting over what happened with the body. One wanted cremation and one wanted burial. Well, daughter was the closest living relative, and girlfriend was she was out of luck, even though she was the medical power of attorney. So it's just very important to make everything as streamlined as possible and make your wishes clear. The executor of my cousin's estate, and I said, okay, great. She said he died over a year ago. I said, oh, that's not so great, because after a year, you cannot admit a will to probate. So the will is no longer valid after a year after your death. She said he's got an $11,000 life insurance policy. And the beneficiary, she goes, of his will is supposed to be my son's. Okay. So in Missouri, she would be his beneficiary because she's his closest living relative. But the probate court was requiring an heir from the other side of the family. So from the dad's side of the family tree. We couldn't find anyone. And were going to have to pay a service $500 an hour. And my client said, forget it. My boys don't care that much. I don't want to go through that. It's not worth it. So it can just be a huge headache if you don't have a will. Uh, and the other piece that the will do for you is where you can appoint the personal representative of your probate estate. So that's going to be your executor. That's going to be the person that's going to work with the attorney to get the assets out of probate and distributed to your heirs. Okay. And then we had briefly talked about probate avoidance devices. And what those are would be beneficiary designations. So when you meet with Tom, you review all of those on your life insurance, your 401k, things like that. You're making sure that those forms are filled out and up to date. You're also having a transfer on death. So that would be on the title of your cars. You should have something there. Beneficiary deeds for your house. So that would state upon the death of the owner, or if you're married, the death of the second spouse, that the ownership of the house should transfer to either a beneficiary, or if you have a trust set up, then it would transfer to your trust. Another way to do it is to jointly own something with someone. So you can either, a lot of people will say, well, I'll put my daughter on the account, or I'm just going to add my sister to the account and we'll just take care of it that way. It's not always the greatest idea. I have had cases where clients do that and the accounts have been completely liquidated and they're left with nothing. Or the family member has been subject to a lawsuit, and that's an available asset. 50% of that account now becomes available to someone if they have a lawsuit against the other family member. So sometimes it's an easy solution, but it's not always the best practice. Okay. And the other piece is just powers of attorney. So in general, you can either have them springing, which means they only become effective if you're incapacitated. Then you can choose if you want one doctor or two doctors to say that you're incapacitated. Or you can say, I want them immediately effective. In most cases, you could have your spouse have immediate powers, and then everyone else would be springing powers. And then, like I said, they're only valid when you're alive. So the second that you die, they're no longer valid. And then you need to choose your agents wisely. So I had a client who chose her daughter, and I got a phone call over the summer that daughter was in a mental institution. Her sister called me and said, I didn't know any of this was going on, but I've been talking to her financial advisor, and apparently she has been depositing all of mom's money in her joint account, and she's been spending it, and now it's gone on drugs, and it just a terrible situation. Um, but mom gave daughter power of attorney, and a lot of what she did was what her what seemed to be above board for the people that were involved until she was, I mean, obviously she wasn't serving mom's best interest, so it was, she wasn't doing her job, but it took a lot of uncovering before we realized that there was elder abuse going on. So with financial and legal power of attorney, like I was saying before, it is preferable to have a financial power of attorney versus having joint ownership. The giving your financial power of attorney the power to step into your shoes and to deal with your assets just how you deal with them is really important. Uh, they would be able to conduct transactions like you do. They could fund your trust for you if there was something that you hadn't put into your trust yet. They could make gifts if necessary, or they could spend down if you needed to qualify for Medicaid, sign contracts, sell your home, change your beneficiaries, file a lawsuit, all things like that. I had client call me today and say, my uncle gave me power of attorney, but the financial institution won't let me invest his money. And I looked at the power of attorney, and sure enough, she had powers to sign checks, cash checks, sign contracts, but not to invest. So she was locked out, and you have an estate plan set up. So you've decided whether or not you want to trust or if you need just a will. What's next? Okay, so if you actually have the trust, like we had talked about, the next step is funding it. Um, so say we meet together and we set up the trust document, you sign it, and then the next step is we go through every single type of asset that you have and transfer those assets into the trust. So they're there so that if you need them, they're ready for you. That there's no second guessing, and that everything is just crystal clear. You want to stay up to date on your beneficiary designations. So it's smart to review everything. My clients say, Lauren, how often do I need to go over this? And I tell them, you know what, at least when you meet with your financial advisor, it's great to, you meet with Tom quarterly or semi-annually, you go through everything. But definitely during tax time, you're pulling out all of your finances. Take an account of what is going on in the past year. Really look at things and see if anything's changed. If it has, then let's get something updated. You can shoot me an email or call me and say, hey, I think I want to change this. And I'll say, okay, great. I think this is what we need to update. Or no, everything's the same. Okay, great. Throw it back in the drawer. Don't worry about it. It's also important to have conversations with your key players so that they know if they need to step in, what they need to do. Uh, I love when clients say, Lauren, okay, we've got this estate plan set up. Can we have a call or a meeting with my kids so they know what to do? Or, can I have them call you if they have any questions? Uh, just so they know where to locate documents, or that they feel comfortable, even who to contact, so that they know, okay, Lauren's the attorney, Tom's the financial advisor. They have their bank accounts other than, you know, Emeritus, they've got Commerce Checking, and know where all of those things are. It's also really important to keep your documents together, and so that your fiduciaries can find them when it's necessary. And so you don't want them having, I've had probate last so long because there's just boxes and boxes of files and assets keep popping up. And it's just a mess. So the cleaner that you can make things for people that are going to take over, the better. And really, honestly, sometimes that's a bigger gift than money itself as far as inheritance. Another important thing is to keep passwords or answers to commonly used questions, um, security questions, um, somewhere. I mean, you don't necessarily need to release that information now, but that you could have it so that people can find it because we live in a very digital age now. And we used to say, let's follow the mail. So we'll wait for the bills to come in. But everything, if you're banking online and your successor trustee doesn't know how to get into that account and pay those bills, that's going to be a big problem. Uh, I had someone tell me once that their husband had bought Elton John tickets and he had spent thousands of dollars on these tickets, but they were e-tickets and he had put the link in his email and his wife didn't know how to get into it. So thousands of dollars just went to waste because she tried every password and combination that she could think of and she couldn't get it. So it's just things like that that you want to just prepare for. Um, the other thing that people always ask about is their tangible personal property. So anything that doesn't have a title. So jewelry, household items, collectibles, and things like that. Um, you can distribute that however you want. You can address it in the documents, or you can actually just leave a handwritten list. Um, but if there's anything of value or something that someone might not necessarily know by looking at what it's worth, to to keep an accurate list of that. So, for example, my mom was a QVC kind of addict for a little while, and she had so many pieces of jewelry that we didn't know what was what. So at one point, she was taking pictures and labeling the back of the pictures with if it was, if it was real gemstones or what it was. And um, that way we knew. So those are just kind of some ideas. But the biggest takeaway is you plan for your financial health, and that is so important. You work really hard for your money and you work really hard to enjoy it. Um, and it's equally as important to make sure that you're taken care of if you become incapacitated, but also that your heirs are taken care of and that you're not leaving a lot of loose ends and a big mess because you didn't plan ahead when it can be relatively simple. And it's not always the most pleasant conversation, but so many people tell me, oh, I'm so glad I just finally have this over with. And once you get it done, it's just a sense of security knowing, okay, this is taken care of. I feel good. With grief, grief and money do a lot of crazy things to people. So I've seen a lot of horror stories. So if you have things set out very clearly, you can avoid a lot of that. So, with that, I think we can open it up for some questions. There is my information as well. So if you want to contact me, if you think of anything afterwards or want to set up an appointment, you've got my phone number and email address as well.
Thank you. I appreciate that. And I guess I make a couple comments real quick. Is I've seen both sides of it. I've had to come in and do some cleanup duty, where after the fact of trying to get accounts that were not titled, not registered, all over the place. And I tell you, for the beneficiaries, it can be very, very taxing on them and long. I mean, years of trying to work out what's what. And I've seen the other side. I've seen where everything's clearly identified, labeled, buttoned up in a box, and they say, when I go, I'm just giving this to my kids, and or they're going to find it, and it's all going to be taken care of, and that kind of peace of mind. And it is one of those things that can easily be put on the back burner. I'll get to that. I got to get it. I got to get it. I got to get it. But anyways, so hope you guys found this interesting and informative. And if you have a question, the Q&A button at the bottom, just type it in, and we can ask Lauren right now for a quick answer. Obviously a will, definitely, and a lot of advantages to a trust. And depending on the type of asset, for sure, of the living trust.
The powers of attorney are a must, and then making sure that you've got a deed for the house so that there's a next owner on the house as well.
That's for sure. That's one that I see a lot of, where the house is not in the trust, or there's no deed on it. So you want to, and that's a big asset for many people. So you want to avoid that going to probate. You might have the investments taken care of with beneficiaries, but without the house and the car and in personal effects, that's where the will or the trust can definitely help out for sure. And the healthcare directives. I mean, we're living longer today. And obviously things like dementia and Alzheimer's are prevalent. And so those power of attorney, what happens if you can't make decisions for yourself? Who's going to make those decisions? And without that power of attorney, it becomes really complicated and difficult. In fact, we keep a lot of power of attorneys. We keep them on file and file them with the investment firms, so that if the day does come, we already have it ready to go. And that power of attorney can go ahead and start making withdrawals to pay for care or anything like that and signing those documents. I do see a question. What area are you located in? And would we meet at your office or someplace else?
So I am in Frontenac. My office is directly across from Plaza Frontenac, and I am happy to meet with clients here. I've met with clients at Caroline Group before as well. Or, I do make house calls, just depending on the area. So I open to many possibilities. It is best when we do have our final meeting, though, to meet at either my office or Tom's office so that we have witnesses and a notary to execute those documents.
I got another question. Could you tell us about the time that it takes to get this done? I guess it can vary.
The usual process looks like you'll fill out the new client questionnaire. We'll sit down and have a consultation. Once I have all the information that I need to draft your documents, it usually takes about 3 weeks. I'll send you the first drafts, and then you review them. You can come back with any changes or comments, and we can meet again to go over any questions if you have them. Otherwise, then once they meet your approval, we'll schedule a signing appointment. I have had situations where we've had from start to finish, it's taken a week because we needed it to go that quickly. I've had situations where it's been almost 2 years now and the documents aren't signed. So yes, if you want to get it done, then I would say we can have it done by the end of the year.
You got it. I got another question in. Deeds, car titles, and should be included with important papers. And then also, do you only have one person as a power of attorney?
Yes, deeds and car titles keep with your important paperwork. I usually recommend having a fireproof safe in the house versus having a safe deposit box at a bank. But keep all of that information together. And then powers of attorney. It depends on your situation. You can name co-agents if you're pretty confident that they will get along and that they won't have issues working together. So you can say, I name Tom and Lauren acting together, but if one of them's not available, then the other can keep acting alone. Or you can say, I want Tom and Lauren, but if Tom and Lauren can't come to an agreement than Tom, Lauren, and Tim acting together. It just really depends on the situation. But if you've got something where you think, oh, I've got two kids and they're not going to have any problems, you can name co-agents.
Gotcha. Okay, got a couple more questions. Great. If a business divestment is involved, does that go into this kind of documentation planning, or is it done separately with separate documents?
It would go into your estate plan, but it would involve additional documents. So it's
Okay.
yes, you would incorporate that, but that would be a more elaborate conversation.
Right, right. More on the business continuation or sale of the business kind of agreements.
Correct.
Okay. Also, got another question. Is there a way to let us know the cost to set up a trust? So I guess it ranges, but I'll let you answer.
Yes. So typically, if we're talking about um, a trust for a married couple, with and I do packages. So it would be a revocable trust, wills, powers of attorney, and then a beneficiary deed for the home. Um, for the couple, the total would be $2,500.
Okay. And
And
healthcare
then,
directives as well?
yes, yes, that's included in the medical power of attorney.
Gotcha. Gotcha. Okay. We got another question. Should a power of attorney be included on bank accounts to make financial transactions easier?
Like Tom was saying, you can keep the power of attorney on file with the institution, but they're not named on the account.
So in other words, they have in the event that the owner of the bank account is incapacitated or unable to make decisions, the power of attorney gives whoever they name, a child, or the ability to go in and make transactions in that bank account for them. Is that right?
Yes.
Yep. Okay.
Yes.
Okay. But I think I know also, like, for example, for our clients that do have powers of attorney, we keep a copy of that and we proactively send that to whatever institution you might have an investment set up with, whether it's Emeritus, Fidelity, Asset Mark, Prudential, any of all the investment firms we use. We like to have that on file with them already so that something happens and, hey, I get a call, mom had a stroke. We need to set up some money. We're doing some rehabilitation or in-home care, whatever. I need to get some money out of mom's account. Well, we've already got the power of attorney set up and we can start that process without trying to find it. Hey, is there one set up? Who has it? That takes a lot of time. So good questions. Would we give you a copy of all documents? So maybe maybe I'll split that up into two areas. For us as an advisor, we do like to keep a copy of the trust. We want to keep a copy, and some of the firms request that it's mandatory. Like if you name a trust as the owner, they need to have a copy of the trust. It remains private and secure, but on our side, we prefer and need to sometimes have copies of those documents. I guess, Lauren, what about your firm? Do you keep copies of your clients' records in case a client couldn't find them, the kids come to you?
Right. I do. And I do keep notations in the file, whether you want me to release them to your children if they do, or your successors if they contact me, if it's okay to release those documents. So I retain them. And then by law, I'm required to let you know if I, for any reason, will no longer keep them. So I keep a digital copy. And then if I am getting rid of that, or, at whatever point that I retire, I will let you know, contact you, and get your file to you, so that you have access to that as well.
I got another question here about leaving money for grandchildren in a trust. So like, how would what's that conversation? You could, the order of succession or the ability to designate multiple
Sure.
grandchildren and add to it.
So you can break it out so that I want to leave a certain percentage to each grandchild, or I want to leave a dollar amount to each grandchild. And then you can say, and if there's any additional grandchildren that are born to me before I die, I want them to be treated equally. So that say your children aren't done having kids, you don't have to come back each time you have another grandchild and update those documents. So you can name your children and grandchildren, and delineate all of that. Or you can say, I want it to go to my children. And if something happens to my child, I want their share to go to their children. So you can really plan all of that out.
Okay.
I've had clients too say, I want it to go to their spouse. So that's a really specific thing that you need to say if that's what you want.
I have one more. It just came in. It's a hypothetical. Designate a percentage of proceeds of grandkids, great grandkids from a sale of a house, potentially, question mark.
Yeah. So you could say, if I still own this house at the time of my death, I want the house sold and I want this percentage to go to grandchildren. If I have great grandchildren, this percentage to remain in trust until they reach whatever age. And you can say, I want my trustee to make distributions for their education or their medical needs or things like that.
We'll re-forward Lauren's contact information.
Sure.
And if you'd like to contact her anytime, just give her a call and she'll be absolutely willing to help you out. Thanks,
Tom.
Lauren.
Thanks. Thanks, everyone.